I will now call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores.
Present.
Senator Orenshaw.
Here.
Senator Lang. Senator Nguyen. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
Here, thank you. Please mark Senators Ellison, Nguyen, and Lang present when they arrive. And welcome everybody to Senate Judiciary Committee on what appears to be becoming a snowy day. So we will get right down to it and not keep you guys any longer than we need you. We have two bill hearings this afternoon. The first bill we're going to hear is SB 120, which I will assist in presenting. And for that reason, I'm going to hand the gavel over to my extremely competent Vice Chair, Senator Flores.
Thank you, Madam Chair. At this time, I'd like to open up the hearing on Senate Bill 120.
Good afternoon again. I'm still Melanie Scheibel from Senate District 9, and I am here, I guess, for moral support for the team that's actually going to present to you SB 120, and I'm here to answer any really hard and mean questions that you ask them. But other than that, I'm very delighted to turn this over to my office intern, Soraya Bonner, who will tell you a little bit about SB 120, and then Nick Shepak from the Fines and Fees Justice Center, who can give you a little bit of background. And really the two of them, I think, can handle any questions, but I'll be here just in case.
Good afternoon, welcome.
Good afternoon, Vice Chair Flores and esteemed members of this committee. My name is Soraya Bonner, S-O-R-A-I-A-B-O-H-N-E-R, and I have the privilege of being Senator Scheibel's intern for this session. Today I will be introducing SB 120, which addresses inequities in how our state's judicial system imposes and collects monetary penalties, as well as how it treats defendants who cannot afford legal representation. This bill is grounded in a simple yet powerful principle: justice should not be contingent on wealth. For many people, a court-ordered fine can become an overwhelming burden. What might seem like a manageable penalty on paper can quickly spiral into a long-term debt for someone living paycheck to paycheck. Missed payments can trigger late fees, collection costs, or even incarceration. This is often a result of a complete inability to pay, not because a person is unwilling to pay. The cycle not only punishes poverty, but perpetuates it, making it harder for people to rebuild their lives. Additionally, when we appoint public defenders, we do so because we recognize that access to legal counsel is a fundamental right, not a privilege reserved for those with wealth. This bill attempts to remedy financial barriers to justice across the state of Nevada. I now want to pass it to Nick Shepak from the Fines and Fees Justice Center to give an in-depth background and description of the amended sections of this bill. Thank you.
Thank you, Vice Chair, committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I am the Nevada State Director of the Fines and Fees Justice Center. What SB 120 seeks to address is two fees that are charged to individuals who are indigent. These fees are never charged to individuals who have the money to pay their fines and fees, and I want to quickly touch on the difference between a fine and a fee. Fine is a monetary penalty. You all set the limits on those penalties. Fees are additional costs that are added on the back end. While they are not technically punishments, for the individuals who receive them, they feel very much like punishments. I want to thank the judges of limited jurisdiction and all the other stakeholders we worked on with this bill. The amendment strikes the vast majority of the original piece of legislation and really simplifies the bill. In Section 1, Subsection 4, we eliminate the ability for courts to charge to get on a payment plan, which we will go into in a bit. And then towards the end of the bill, in Sections 2 through the end of the bill, we simply repeal statute that allows for the charging individuals for the use of public defenders. These are indigent defense fees. Fines and Fees Justice Center, along with the Duke Law, conducted a national study on fines and fees and the impact on individuals. What we found is that 1 in 3 Americans have been directly impacted by fines and fees in the last 10 years. And 98% of those who were impacted by these fees reported an impact on their daily life. 99% of parents had to cut back on essentials. 51% had to cut back on 2 or more essentials. 35% had challenges obtaining food, and 27% had faced the housing hardship directly related to trying to pay their fines and fees. So when we're talking about payment plan fees, what we're talking about is an individual who is sentenced to pay a monetary sanction, whether this is from a traffic ticket or from a misdemeanor or a felony offense, and they are unable to pay that fee in full at the time of sentencing. They can ask to be placed on a payment plan in almost every court in the state. What we found is that some courts charge an additional fee to access those payment plans, meaning that if I can pay my fine and fees in full, I pay less than someone who does not have the money to do so. What we found when we surveyed courts across the state is that the justice is not equal, as each court has set its own standard. So we were able to get in communication with 40 justice and municipal courts. 19, which was the largest number, charged no money to get on a payment plan. You saw 2 charge $10, 1 charge $20, 10 charge $25, 2 charge $45, 6 charge $50, 1 $75, and 2 $100. Now, I will say that 4 of these courts charged multiple fees depending on how much you owed. So those 75s and those 100s are courts that have a split fee schedule. But what we are seeing is extremely inconsistent fees. So if you're lucky enough to have your traffic ticket or other offense in one court, you can get access to a payment plan for free, where if you are in a different court, it can cost you $50 or more for the pleasure of getting on that payment plan. When we look at indigent defense fees, the research on this was very interesting. So we found that, of course, Gideon v. Wainwright in 1963, the Supreme Court said that individuals who were indigent had a right to public defense. In 1975, this body passed AB 70, which allowed for the judicial branch to charge for the use of public defense. I was able to, through the library, get the minutes for those meetings, and at the time, there was a perceived or real issue with they believed there were individuals who could afford counsel, but they were choosing to use public defense. We had no indigency standard. It was simply a question at the time, can you afford a lawyer? If the answer was no, one was appointed to you. Their way of fixing this real or perceived issue was to allow for the charging of a fee to try to deter people from using public defenders. Since then, we have created an indigency standard. We now ensure that everyone who uses our public defense system is in fact indigent and does not have the money. We find that we have a very similar access to justice or difference in courtrooms with this specific fee. So we got data from 2003 from every court in the state, and 10 justice and municipal courts in Clark and Washoe did not charge public defense fees to a single defendant. 10 rural counties, so these are people who use the Department of Indigent Defense, or DIDS. Those rural counties, 10 of them didn't charge one individual. We saw 7 justice and municipal courts in Clark and Washoe did charge at least some individuals this fee, while 4 rural counties did, as well as Washoe and Clark District Court. We were able to get judge-level data within some of these courts. So when we looked at Clark County District Court, we found that 5 judges assessed defendants' fees on 75% or more of their cases. So if you found yourself in this court in front of this judge, you were almost certainly getting charged this fee, which could be $250 or more, while if there was 8 judges who charged less than 5% of defendants, so if you were lucky enough to end up in that courtroom, you were almost certainly not being charged this fee. We looked at Sparks Municipal Court, and one judge was found to be 20 times more likely to issue a defendant this fee over one of his colleagues. So what we're seeing is a deeply inequitable levying of these fees across states, or across the state and across across the state, across different judicial districts, and even within those courts across courtrooms. We looked into the collection rates of these fees. In many cases, they're very low. In 2023, what Clark County District Court reported to us is that they collected 8.17% of what was assessed. We saw higher collection rates in Washoe, but on the next slide, I'll explain why we believe that may be. And then out of the 11 courts and counties that did charge this fee, they collected less than $10,000, and many collected less than $5,000. So it is not really a revenue driver by any means. Here is where we find some additional issues with these public defense fees. Is we have as many of you know, we have the funding formula and the reimbursement formula for our rurals through DIDS. Well, when an individual is charged a public defender fee, they pay this over time. There is supposed to be a reporting process to the Department of Indigent Defense. However, it is a hodgepodge of whether or not this is being reported, and how it is being reported is very confusing. It is very likely that we have reimbursed some counties for defense that they have also charged the defendant for, resulting in a double dipping, not intentionally, but just due to the way our processes are set up. We also have reports that, and we've talked to people in the courts, often when these fees get put onto individuals right at the end of their sentencing, if they go to the Nevada Department of Corrections, they show up as restitution. So when an individual's family puts money on their books, or they have a job in prison, and a deduction is taken from that money to pay for restitution, not all of that money is making it to the victim. Some of it is going to pay these court fees, specifically this fee. And so we are not getting all the restitution to go where we want, where we intend it to go. So essentially, to recap, we have a system of fees that are antiquated, they are disproportionate, and they are not the same from courtroom to courtroom, judge to judge, and there are a litany of other issues with both collecting these fees, where the money goes, and the possibility that we are paying twice for the same defense. And so for these reasons, we believe that it is time to eliminate these old, outdated fees. And again, we worked very closely with all the stakeholders to ensure that we didn't overstep the boundaries into judicial discretion. And with that, we would be very happy to take any questions.
Thank you for the presentation and the breakdown. Members, any questions? We'll start off with Senator Ellison, please.
Thank you, and I apologize for being a few minutes late, and then I apologize for not being able to hear very good to you. But I do have a couple questions, if I may. What kind of crimes, is this strictly traffic and stuff like this, or is it light duty crimes?
Nick Shepak for the record. Thank you, Senator Ellison. Anytime fines and fees are levied, the court has the opportunity to allow a person to pay in payment plans. When it comes to the public defender fees, it could be any time that a public defender is assigned and somebody either pleads guilty or is found guilty. So it could really run the gambit. If it's in a municipal court, where these are assessed sometimes, those are going to be misdemeanors. If it's at a district court, those could be felonies. It's going to be any time that a public defender is assigned that this fee could be applied.
Follow up, sir.
Please follow up.
One of the questions that, in ILCO, they allow them to make payments. and it works out pretty good sometimes. My biggest problem was my wife, deceased wife, worked there for 33 years, and when the single mothers come in and couldn't make payment or before they get arrested, she would go in the back and come back out and tell her the judge waived the fines and let them go, and then she went and paid the fines for them. And I didn't know this for years because they testified that at her funeral. So she would go because she knew the hardships they were going through. So, but we do community service out there quite a bit. Those that want to do community service, they have that option, but I noticed that doesn't say that in there. I use them for the 4th of July and stuff like this, you know, to help set up tables and do all this kind of stuff, and it works out really good. So I don't know if that doesn't identify that. Is that an option that they could do, or is that up to the court? Oh, she says she's shaking her head.
Nick Sheepak, for the record, I do first want to say we are all sorry for the loss of your wife, and she sounds like she would have made an excellent employee at the Fines and Fees Justice Center. But the community service is always an option, and this does not intend to limit that in any way. But for individuals who, for whatever reason, either can't complete the community service, you talked about a single mom maybe working 2 jobs, finding the time, sometimes paying the fee is the best option. This is just to make sure that, or paying the fines is the best option. This is just to make sure we don't add an extra financial burden onto that individual if they have to make those payments over time.
Well, thank you very much. It's a great bill. Thank you.
Thank you. Next, we have Senator Hansen, please.
Thanks, Nick. Great to see you as always. The bill that I was going to talk to you about, I kind of got rid of. I mean, there isn't much left. Question I have, though, is administratively, okay? Originally, the bill had a $10 payment, so I guess I can still do that. Do the courts currently have some sort of process to keep track of that? And are the payments supposed to be made to the court? And then is it paid off, you know, with time? And then what happens if somebody is late on their payment? Are there any penalties? There's no interest, according to the original bill at least. You know, what incentive do you have to make sure that whatever the payment plan is gets followed? And if they don't follow it, what happens?
Nick Sheepak, for the record, thank you so much for the question, Senator Hansen. So one of the reasons the bill ended up like this with all that removed is the courts have to be able to set their own processes, right? If we go to set their processes through this body, there was constitutional concerns. So what we're seeing is a litany of consequences, and it really is dependent on both judicial discretion and by each court's own rules. So if somebody fails to make payments on a payment plan over time on a criminal penalty, you could issue a warrant. That does happen quite often. If somebody fails to make payments on a traffic, they can be sent both to civil and they can have their driver's license suspended currently. Now, how each court chooses to utilize these punishment hammers for non-compliance is going to be up to each one of our individual courts, but they have a litany of things at their disposal to ensure that people are complying.
Okay, they already have some process in place. But one of the complaints you had on all your slides was that you have this very great variation based on courts, but you just told me you're going to allow each court to have its own process. Isn't that going to defeat the purpose of at least a part of this bill?
Nick Sheepak, for the record, I wouldn't say that I'm going to allow each court to have its own process, but I would say that unfortunately, with an ununified court system, this is how almost everything in our courts work. Getting them to act in a unified way has proven to be very difficult, and it's just the nature of how we operate here in Nevada. What this bill can do is ensure that we don't charge people who can't afford to pay in full to pay payment plans, fees, and we can eliminate this fee on public defense, which would this would then be unified across. But each court because we don't have a unified court system, really does have the authority to set its own parameters.
Okay, well, I mean, your main point in your slide was the lack of uniformity in the courts, where in my hometown of Sparks, the guy's charging 20, but that may be the rules that he's following in his own courtroom. So anyway, no, I think there'll be some people I hope that testify, because I just kind of want to get some understanding of, you know, if I don't pay, is there a collection agency that takes over? Does the city actually do collections? If I just deliberately refuse to pay the bill, is there a penalty that, you know, I can thrown in jail for a while, you know, that kind of stuff. As far as the public defender side of it that you brought up, so that is an interesting situation where there could be, you know, double payment basically for the same services. Right now, do you have any stats on how many times that may have occurred where you guys actually think that, you know, in one of my rural counties, say Humboldt County, got paid through the indigent services fees or whatever it was that we set up not too many sessions ago, and then somehow managed to charge the defendant as well? So there was, you know, double payment?
Nick Sheepak, for the record, it has been extremely difficult to track how many times that possibly has happened. Anecdotally, we have reports from DIDS that say that they have, from some courts, and I don't want to get the county wrong, but I can get you this information, that says they have collected no money for indigent defense fees. Then there was court watchers from UNLV who were exploring these more rural courts who found that these fees were in fact being assessed. So they're reporting that they're not assessing them to DIDS, yet when people are in court, they are seeing them being assessed. But the scope of the issue, I can't speak to.
Okay, so basically you have anecdotal evidences by court observers. You don't have any factual data that shows, yeah, Ira Hansen got hauled to court and he claimed to be an indigent person, and I got a public defender, and the state reimbursed Humboldt County $5,000 for my case, but then Humboldt County turned around and charged Ira Hansen $5,000 to help offset the cost of that. You don't have any of that at all?
Nick Sheepak, for the record, when working with DIDS and they gave us all their data, the way they explain this is essentially they hit a cap in the rurals, and then everything is reimbursed after that. So it's not on a case-by-case basis. And then payments come in, especially if a person is incarcerated, for that indigent defense in a rolling, like, it'll be every time somebody puts money on your books, some of that money goes to pay that indigent defense. So, like, it is, we have not found a way to possibly track individual payments to that direct fee, and then when the reimbursements come in. It was in our talks with the former director of DIDS that this confusion was brought to our attention, and they said that it is very likely that individuals are being charged for indigent defense, and those payments are coming in at a time that was paid for by the state, but the tracking in the data is very difficult to parse.
So it's still May at this point. We don't have any actual cases, but it looks like it could have happened.
Correct.
Right? Okay, very good. Thank you, Mr. Vice Chair.
Members, any additional questions? Senator Krasner, please.
Thank you, Chair. So I'm just I'm looking at this and Section 1, subsection 7. So a person commits a crime and they're found guilty or responsible of committing the crime. So police arrest them, district attorneys prosecute them, they get their hearing, judge sentence them, and then they just default. They set up a payment plan. What if they just, I mean, I know you're talking about these poor people, and I do have a heart for people who really can't afford it, but what about people who just say, yeah, I want that payment plan, and then they just default on it? Ha, ha, ha. It's a big joke. I did the crime, police expended their money, district attorneys expended their money, the state expended the money on the court, the judge. I got the payment plan, ha, 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 and I'm going to default and not pay you. What about that?
Nick Sheepak, for the record, thank you for the question, Senator. First, that section of the bill is completely striked in the amendment, so that that section is no longer in there. The only thing that this bill does is eliminate payment plan fees. Payment plans already exist, and it eliminates public defender fees. It does not do anything else in the original piece of legislation. But second, to answer the question more generally, when a defendant is charged money, whether or not they're on a payment plan, they are either on a payment plan and able to pay over time, or they have a pay-by date. There is nothing to stop one individual on either one from saying, ha, ha, I'm not paying. The court then uses the tools it has to try to collect that money. But whether or not you're on a payment plan does not change whether or not you could still abscond and not pay, regardless of if you have a pay-by date or if you are on a payment plan. But with the amendment, the section that you were referencing is completely striked from the bill.
Okay,
Please.
thank you. So you had said criminal fine, criminal penalty. Those were your words. So what type of crimes could somebody be found guilty or responsible of and then set up the payment plan and say ha, 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 and thumb their nose at the court and the whole legal system and go back to court and get their payment plan reduced because they didn't pay? What kind of crimes are we talking about?
Nick Sheepak, for the record. Thank you, Senator. I'm having a slight difficulty understanding the question. There's nothing in this bill, as amended, that allows for a reduction in the future. This just doesn't allow for an initial charge to get on a payment plan. That section that you're referencing, and I believe you might be looking at the original bill, there is an amendment that strikes that entire section. So if somebody was on a payment plan, didn't make payments, and it was criminal penalties, the courts could issue a warrant for arrest because it is non-compliance with requirements of a criminal charge. So they could absolutely, if you said, ha, 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 I'm not paying my criminal penalties, they could send Washoe County or any other police department, they could issue a warrant, you would get arrested, brought before a judge, they would ask you why you absconded.
Okay, thank you.
Yeah.
Members, any additional questions? Senator Ellison, please.
Thank you, and I'm glad you answered that. I've been there, done that. I'm going to get Ira out of jail. So anyway, question is, this does not exclude if somebody is, say they broke into a place and did property damage or whatever, that court can still issue that person owes restitution back to that person. And by that, then the court, if they don't, then they have the right to turn around and sue them, and then there could be a bigger problem for them. So that's still in the law, isn't that correct?
Nick Sheepak, for the record, yes. And we even clarified that this is not regarding restitution, so this does not touch anything to do with restitution.
All right, members, any additional questions? Seeing none, thank you for your thorough answers. If I could ask for you to sit back in the gallery, and at this time I'd like to invite those wishing to testify in support of Senate Bill 120 to please come forward in Carson City or Las Vegas. I see no one in Las Vegas, but I do see folk here in Carson City coming forward. And I'd like to remind you if you could please limit your remarks to 2 minutes. Whoever wishes to go first.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the committee. My name is Denise Bolaños Heredia, Bolanos Heredia, and I'm the Associate Director of Return Strong. We advocate for the rights and dignity of incarcerated people and their families, and we strongly support Senate Bill 120. This bill is personal to me as the wife of an incarcerated person raising 3 children alone. I know firsthand how court-imposed fines and fees create a financial burden that's nearly impossible to escape. At one point, I was working 3 jobs just to stay afloat. I made an electronic payment to replace my lost license, but by the time the charge was processed, I had already paid rent and didn't have enough to cover it. That single missed payment led to my license being suspended, something I only discovered when I was pulled over after my car broke down at a red light. To reinstate my license, I had to go to court and pay even more fines, costs that I couldn't afford in the first place, so for 3 months, I simply didn't drive. I walked my youngest daughter to school and to the grocery store, but I was lucky. Both are just 2 blocks from my home, and I work remotely. But what happens to those who don't have that privilege? What happens to the people who can't afford to drive, but also can't afford not to? This cycle is even more devastating for those recently released from prison or families like mine trying to survive on one income. SB 120 takes an important step towards breaking this cycle and ensures financial hardship doesn't prevent people from moving forward. I urge you to support SB 120 and thank you for your time.
Thank you for joining us. Welcome.
Good afternoon. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. We support this bill and urge the committee to support it as well. Thank you.
And thank you for joining us. Good afternoon. Welcome. Can you also remind the committee in what district you live in? Proudly.
Proudly. My name is Aisha Goins, Aesha Goins. Senator Flores is my senator. I appreciate Chair and the committee for hearing this bill. I support this bill on behalf of the NAACP Prison Committee and specifically my father, Matthew Goins. Thank you.
Thank you for joining us. Please.
Good afternoon, Chairman and members of the committee. My name is Shane Piccinini, S-H-A-N-E, P-I-C-C-I-N-I-N-I. I am with the Food Bank of Northern Nevada, and as you may recall, we have done a lot of anti-poverty work, in our almost 40-year history now. We thank the sponsors for all of the work that has gone into this bill, and we ask for your support. Thank you.
Thank you. Good afternoon.
Good afternoon, Vice Chair, Committee. My name is Zach Bucher from the great city of North Las Vegas. Here in support, we weren't originally in support, but it's a testament to the bill sponsor working with everybody, as well as her intern in the Fines and Fees Justice Center. So happy we were able to get to a position of support. It doesn't always work that way in this building, but it did this time, so thank you very much.
And thank you for joining us. Welcome, sir. I think your microphone might be off.
The red light,
there it is.
There we go. Okay. I just wasn't speaking. I apologize. Good afternoon, Mr. Vice Chair, members of the committee. My name is Keith Lee, Keithlee. I represent the Nevada Judges of Limited Jurisdiction, and we are here first to thank the sponsors, Senator Scheibel, Mr. Shepak, the administrative office of the courts, the district courts. We've all been involved in discussing this bill, and we're all very pleased to support the amendment as it comes forward, and can assure the committee members that, at least for the Nevada Judges of Limited Jurisdiction, we do everything we can to enter into payment plans that make sense. And in many cases, if they're not able to make the payment, then we sit down and talk with them again and try to make it happen. And to answer Senator Ellison's question, we still employ a lot of community service. We find that at the end of the day, that's often more productive and better suits the situation. So I want to thank everyone involved with this and try to answer any questions if there might be any, Mr. Vice Chair.
Thank you. I don't think we have any questions, but we do appreciate you being here today. Good afternoon. Welcome.
All right. Good afternoon, Chair and members of the committee. For the record, my name is Tara Webster, Tarawebster. I'm the policy manager for the Progressive Leadership Alliance of Nevada, here in support of Senate Bill 120. We view this as a common sense bill that addresses a criminal justice system funded at the expense of low-income individuals. While we support this bill in its entirety, we want to emphasize that public representation for indigent defendants is a right guaranteed by the Constitution. Nonetheless, jurisdictions are permitted to impose fees for court-appointed attorneys. If defendants are convicted, these fees can be deducted directly from their commissary accounts, leaving inmates without access to essential items such as toothpaste, deodorant, clothing, or the ability to make phone calls to their loved ones. For less serious offenses, such as traffic violations or jaywalking, where individuals might need to set up a payment plan, these fees create an unnecessary financial burden and hardship. On behalf of the Progressive Leadership Alliance of Nevada, we ask for your support on SB 120. Thank you for your time.
And thank you for joining us. Anybody else in Carson City wishing to testify in support of Senate Bill 120? Seeing none, BPS, do we have anybody wishing to join us over the phone in support of Senate Bill 120?
If you would like to testify in support of Senate Bill 120, please press star 9 now to take your place in the queue.
Hello, can you hear me?
Yes, we can.
Okay. Hello, my name is Yesenia Moya, Yesenia Hello to my senator, Senator Flores. Hi, members of the committee. I'm here in strong support of SB 120 because I have seen how court fees, including public defender fees and payment plan fees, all of these push our people into further financial crisis. I am somebody that has had to pay and has had to go on payment plans, and there's been a lot of the opportunities for me to get that finished. I was deeply disappointed to hear the suggestion that people use payment plans to laugh at the court. The reality is far from that, because no one struggling to pay these fines and fees find it funny. For many of us, the choice isn't between paying the court or refusing to be accountable. It's between paying the court or feeding our children, paying rent, or even keeping the lights on. I've had to choose between taking the bus or walking to work. Nevadans don't ask for payment plans because we want to evade responsibility. We ask because we have no other option. If we could afford to pay up front, we would. But instead, we're burdened by extra fees that make it even harder for us to break free from the system and do our due diligence. And that's not justice. It's just a punishment for being poor. SB 120 is a step toward fairness. It ensures that our legal system isn't profiting off of people's hardship. It acknowledges that financial struggle is not a crime and that no one should be forced into deeper poverty because they needed a public defender or a payment plan. I urge you to support SB 120 and show that Nevada's values really values justice over harmful financial penalties. Thank you for your time, and thank you to Nick for bringing this forward.
It's great hearing from you, Ms. Moya. Thank you. BPS, next caller, please.
Good afternoon, and thank you. My name is Manuel Santamaria. That's ManuelSantamaria, and I am with Battleborn Progress, and I want to speak in support of SB 120. This legislation ensures that low-income individuals are not burdened by the cost of legal representation and repayment plans. By eliminating the public defender fees, it recognizes that people facing economic hardship should not be charged for constitutionally required legal services. Furthermore, any fees for payment plans help formerly incarcerated individuals avoid accumulating additional debt as they work to rebuild their lives. Taken together, these reforms advance equal justice, promote equal access to the courts, and contribute to greater economic fairness in our justice system. Thank you.
And thank you for joining us. BPS, next caller in support of Senate Bill 120.
Good afternoon, committee chair and members. My name is Luisa Benezano. For the record, LuizaBenisano. I am the Campaigns and Community Engagement Manager for Planned Parenthood Votes Nevada, and we are in support of SB 120. Thank you.
Thank you for joining us. Next caller in support, please.
Thank you, Vice Chair. The line is open and working. However, there are currently no other callers wishing to testify in support.
Thank you. At this time, I'd like to invite anybody in Carson City or Las Vegas to please come forward in opposition to Senate Bill 120. Seeing no one in Carson City or Las Vegas in opposition, BPS, do we have anybody wishing to join us in opposition over the phone?
If you would like to testify in opposition to Senate Bill 120, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, there are no callers at this time.
Thank you. Lastly, I'd like to invite those wishing to testify in the neutral position for Senate Bill 120 to please come forward, Carson City or Las Vegas. Seeing none in Carson City or Las Vegas, BPS, anybody wishing to join us over the phone lines in the neutral position for Senate Bill 120?
If you would like to testify in neutral for Senate Bill 120, please press star 9 to take your place in the queue. Chair, the line is open and working. However, there are no callers.
Thank you. Madam Chair, any closing remarks? Any closing remarks? No? With that, I'd like to go ahead and close out the hearing on Senate Bill 120, and we will give the gavel back to our chair.
All right, thank you so much, Vice Chair Flores, and thank you to the committee for hearing SB 120. That brings us to our next hearing of the afternoon on SB 152. We do have our presenters down at the front already. I will invite you to go ahead and start whenever you're ready.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. For the record, James Orenshall, I represent State Senate District 21 down in Southern Nevada. With me here is Michael DeLee, who is co-presenting with me. I want to thank the chair and the committee for hearing Senate Bill 152. Senate Bill 152 enacts provisions relating to electric vehicle charging stations in common interest communities. According to the Nevada Real Estate Division of our Department of Business and Industry, Nevada now has 3,711 homeowners associations, which represent the owners of 623,917 housing units, roughly half of the state's 1.3 million homes. As you probably know, homeowners associations, or HOAs, have significant control and influence over many aspects of a community, including paint colors, lawn care, and exterior property modifications. And this is why Senate Bill 152 is here to address electric vehicle charging stations. Electric vehicle sales in Nevada have grown in recent years, and our state has invested in EV infrastructure. Electric vehicle sales in Nevada increased by 54% from 2022 to 2023 alone, and Nevada is in the top 10 states for percentages of registered electric vehicles. As electric vehicles become more popular, we want to ensure that homeowners have the ability to conveniently charge their vehicles at their place of residence. According to studies from the MIT Climate Portal, their insights into the future mobility study, and statistics from the Department of Energy, electric vehicles produce less carbon dioxide than similar makes and models that are gas powered. And that's just one benefit of electrical vehicles. And I myself, in terms of conversations I've had with some of my constituents who live in homeowners associations, some who own electric vehicles and some who are on the fence thinking of buying them, one big concern has been being able to charge them conveniently at a place that's not inconvenient. I've had some constituents tell me that going to a fast charging station is sometimes not convenient for them. And if there were opportunities within their homeowners association, they might be more likely to consider purchasing an electric vehicle. With your permission, Chair Scheibel, I'd like to turn the presentation over to Michael DeLee, who I've been working with on this legislation. Also, I want to point out to the committee there's an amendment we submitted. We've had some conversations with stakeholders, and that amendment attempts to address some of the concerns that a lot of stakeholders had. I don't know if we've addressed every concern yet. I'm still, we're still talking to stakeholders, and I'm still trying to address the concerns as they arise. But with your permission, I'd like to turn it over to Mr. DeLee, and then I'm happy to stand for any questions.
Absolutely, please go ahead.
Thank you, Senator Scheibel. For the record, Michael DeLee. And I'd like to start by giving thanks to the Senator for bringing this important legislation forward, and also an acknowledgement to the true source of the legislation, which is Jerry Patterson. I hope he'll be joining us on the phone with his support. He's a owner of a condo in Las Vegas, and expressed this concept to me, which I was able to relay to the Senator. And it's an interesting concept because the problem is not really one of government, unless you consider an HOA a government, which actually they kind of are. So it's cutting through the red tape. And that's what we're trying to do, is make something possible that really might not otherwise be possible, because a charging station could be interpreted as a capital improvement, even though under the circumstances that we envision in this bill, it isn't. We want to define it as a convenience and something that is no cost to the unit owners themselves. So that's in the amended version, so I want to work from that. Section 1, based upon input that we received, it was thought prudent to take that out, not deal with anything to do with individual unit owners. So we'll leave that for another day if it's necessary, and focus on the common areas and what we can do in common areas and those amenities that can be put to the benefit of the owners themselves and their guests who might come to visit them and might not otherwise be able to charge conveniently. So that brings us to what is Section 2. We wanted to clarify there that the placement of these charging stations would not have any direct impact on the cost to unit owners, either initially or down the road. So that if a association chooses to take this route, they have to make sure that it's not going to show up in a reserve study. They're not going to have to pay ongoing cost. It's going to have to be done in such a way that it's not going to charge everybody for this. And that's the intent of the legislation. If we're going to make it easy for this to happen, it's not going to be at the expense of other unit owners who might not benefit from this. And then we struck Section 3 for the reason that it doesn't mesh well if Section 1 isn't in there. So that leaves us with the definition in Section 4, and the only change was a recommendation to drop the last two lines, which flow on the next page on my copy, so that we don't include the batteries and the solar panels as part of that, even though they might be attractive. It was felt best not to include it in the definition of the charging station themselves. So that's how the work bill, and I'd like to answer any questions you might have.
All right, thank you so much. Questions from members of the committee? Senator Ellison.
Thank you. And I did meet with the sponsor of the bill, and we had a couple questions. This is strictly going to be on basically single-family dwellings in like a HOA. Is that correct? They're not going to be an apartment complex type situation. Is there, or maybe you can answer that?
For the record, Michael DeLee, to Senator Ellison, it's under Chapter 116 is the definition, so we've delimited it to just that section. Okay. And the idea is to look at what amenities might be in a common interest community that would be sort of bottled up and not otherwise available. So we may have some improvements made in a place that was built, just to give an example, in the 1970s. There's like tennis courts that were put in. Some people still do that. It's good sport. But at the time they used mercury vapor lamps, which take a tremendous amount of power. And nowadays you can get the same amount of light from a light powered by solar. So in a lot of places you'll see that excess capacity, but you can't really free it up because there's some red tape there dealing with either CCNRs or bylaws in those types of scenarios in a common interest community. So that's what we're after, is specifically 116, if that answers the question.
And for the record, I do have a gas guzzler and love it. So that's as far electric as I'm going to get, okay?
And, James Orange, Hall State Senate District 21, for the record. Senate Bill 152, if it passed, wouldn't require anyone to buy an electric vehicle, and it wouldn't require any association to install any stations. But I think that it might give some folks who are on the fence and thinking, should I try one of these, a little more optimism in terms of being able to charge within their community, not having to go find a station and sit and wait and see if there's place where they can go to the bathroom or time to wait, because I know those are fears that have been expressed to me by some of my constituents. I've got a lot of older HOAs, and so this is meant to try to address that concern.
Mm-hmm. Senator Hansen.
Thanks, Madam Chair. My question, Section 1, the strikeouts. as I read it, the current law is that if you want to have an electric charging thing in your own, on your own property, you can. But with the strikeout, does that mean that it's only going to be able, you're only going to be able to be charging things in the common area? Or is there other sections of Nevada law that cover this in addition to the strikeout?
James Orange State Senate District 21, for the record, through you, Chair, to Senator Hansen. The language in...
Please go direct.
Oh, thank you. Senator Hansen, in Section 1, Sub 1, that was new language proposed in this bill, and nothing in this bill is meant to try to prohibit someone if they want to charge at home using a home charger, but there was some concern that the language might be interpreted to let an individual unit owner set up a charging station for hire, which is not what my intent was. My intent was to try to protect people if you want to charge at home, that the HOA couldn't prohibit that if your home overnight charger. But that I'm not trying to have anybody set up a commercial fast charger for 35 minutes, pull up to James's garage and get a fast charge. That would be for the association to decide if they want to put it in a common area and, not to do away with playgrounds or open space. If the association decides, the board of the association decides that's the way to go.
Okay, no, I was confused then. I thought that's original language in the original bill, that strikeout then? Is there a current law now that allows me, if I live in a HOA and I want to have an electric vehicle, is there anything in law that prohibits me from, plugging in my garage or something like that? I mean, because the thing that interests me about this bill is this isn't prohibiting anybody from doing it in their own property with their own vehicle. This is creating a kind of a unique station in the common area. So I'm kind of wondering, why would you need that in an HOA? Because if you can do it in your own home, who are the people that are going to be using the common area? If you can do it in your own, why do you need to do this in a common area?
For the record, Michael DeLee to Senator Hansen. There's a capacity issue for one. The rate of charge for a visitor that might come to visit is going to be quite a bit longer if you have, say, a 200 amp charger set up or 200 amp service, but might only support a 30 or maybe if you're lucky a 50 amp charger. That guest might have to be overnight, and you might not have anticipated that guest to be overnight. Furthermore, you might have people that are coming and going that just need a charge, and that's popular in some areas, but in some areas you don't actually have a lot of chargers in those neighborhoods. With the capacity that does exist and the infrastructure in some places, they have the capacity, others don't. Some do have this capacity. This allows them to take advantage of that physical capacity without waiting what sometimes might be a year or two for a very large upgrade from the utility, because they might already have that capacity. So we're encouraging common district communities to do an assessment of their capacity from an electrical perspective, and then reach out to companies that are able to do this at no cost to any of the unit owners. It might look like a business, okay, because people are going to pay to get charged. It's not free, but it's not, nobody's setting a hot dog stand here. This is something that we want to make a priority, just like we have made a priority for, say, other things for HOAs to do in that fashion.
Okay, but this is enabling, right? You don't have to build these stations, first of all. But the other problem that comes up is when you build it in a common area and you have a bunch of people parking their cars there to get them charged, even if it's 45 minutes or overnight in some cases, it does say in here that the HOA association does not have to take into account the concerns of the person who may be living nearby to where this charger station is going to be. So I got a little bit of an issue with that, in that you're forcing one minority group in a HOA to bear the burden of everybody who wants to park their vehicle overnight to have a charging station there, blocking traffic or whatever. In my mind, because common areas are not necessarily like a park or something. These can be common areas inside a residential neighborhood, and by having a bunch of people parking vehicles in there to charge them overnight especially, it can really inconvenience, I would think, the people in there. But the way the bill's written, those people that are being impacted by that don't seem to have much say in trying to stop it. But anyway, so just a little food for thought. I mean, I don't have a dog. Just kind of curious about some of the logistical aspects of putting a station in a common interest community like this. Thanks, Madam Chair.
Thank you. Other questions from members of the committee? If not, I actually do have a couple as well, reading the bill as amended. So what's the intention in a HOA community where everybody has like a unit, like condominium, so without attached garages? If I live on the second floor, is the idea here that I can't set up a charging station in my assigned parking space?
James Orchall, State Senate, District 21, Chair Scheibel. I don't believe the bill prohibits that. I think that would still be up to the association and the board, even if this bill passes, in terms of someone charging their own electric vehicle just on their own and not in a common area. That's how I understand my intent of the bill.
Okay, so I think what's confusing me then is the strikeout in what used to be subsection 3, because that was the section that gave the association the power to adopt regulations. And I'm guessing that it was, advocates for HOAs who asked to have this stricken. But it seems to me like the HOAs, maybe their voice can speak to this when they come up here. I would think they would want to be able to create rules that say, you have to get approval to put a charging station in your parking space, or we can only have, one of every 3 parking spaces can have a charging unit in it or something like that. Otherwise, I could see an issue where if I live in a condo and each unit has 1 or maybe 2 spaces, I could see the issue becoming every single space having a charger installed at the owner's expense and just sitting there. Yeah, thank you.
For the record, Michael DeLee, to Senator Scheibel. What was stricken from Section 3, if you took in the perspective that this is being driven by the board itself, so the board is the subject of this current version of legislation, they're going to make their rules for themselves. So 3 really applied to what Section 1 was applying to, which was individual unit owners that might want to have something in their garage or in their proprietary spaces. We aren't addressing that in the current version that we want to have passed. So if the board itself is going to focus only on common areas and something that is like a existing parking lot not assigned to someone, naturally they would decide what regulations apply to that and who uses it and how that's going to go. But I think the question is, how do we regulate something that might be in a proprietary space that is only applicable to 1 unit owner? And the answer is we don't. The current version of the bill as proposed, the amendment, doesn't touch that in either 1 or 3.
Okay, then I think I'm a little bit confused, because reading the original bill, I understood the purpose to be that it provides some pathway for unit owners to be able to install a charger where they want a charger. The new version of the bill, the amended version, allows the association to install a charger, but I can't imagine that they don't already have that power.
For the record, Michael DeLee, to Senator Scheibel. The complication with the current structure of the boards is that it's likely to be considered a capital improvement in a lot of the governing documents. It's likely to go through a review process, whether or not it has to be in an assessment for what the project is, what the costs are, whether it's going to be part of a reserve study, whether you need, and this is probably the most important part, a vote of all of the owners, which apparently, if you're involved in an HOA, is just about impossible to get. And the legislature has chosen in years past to provide workarounds, like, for example, budgets or things like that when an HOA needs to do something, to put the onus first on the board and then allow owners to come in under certain circumstances if they don't like certain things. So because of the need for this, it looked like the best way to do was to provide enabling legislation for the HOA board to take charge, pun intended, and maybe be approached by some of the companies that actually do this and say, look, we can come in, we can do this, make it easy, it won't cost you anything, we'll get a lease in a space here. But without this, they would have the impediments in those governing documents, whether it's the declarations, CCNRs, bylaws, et cetera. And this hopes to cut through that to make it possible if the infrastructure is there. In many cases, it won't be there. But for those instances where it's there, we're hoping that this gets us there. It doesn't touch the issue about a particular unit owner being able or not being able to have something either in their own garage or in an assigned space. Some of the concerns that were brought to us about it was just going to make a big problem with defining a lot of things and construction and definitions and zoning, and it was easier for us to just say, well, let's focus on what we really want to do here, which is the HOA board enabling legislation.
Okay, that makes a lot of sense, and that did answer my question. I appreciate that. I was not thinking about those barriers that the HOA board would face in trying to establish or build these charging stations. But now I understand that this does make it quicker and easier to install those charging stations so that people living in the community can have quicker access to a charging location. So I appreciate that. I think there was also a question from Senator Ellison. Go ahead.
Thank you, ma'am, for bringing that up, because that was one of the questions I had. Mostly where you have multiple floors and you have a common area you go through for the apartment. Problem is you're going to be penetrating concrete walls, you're going to be hitting barriers. Next thing you know, there's going to be conduit everywhere. So I think that you're right, that's an issue that I talked to the sponsor about, that creates a whole different new problem to the structure. Thank you.
All right, any other questions? Not seeing any. Thank you so much for your presentation and for answering all of our questions. We'll move now to testimony in support of SB 152. Anybody wishing to testify in support in person in Carson City or Las Vegas is invited up to the front to do so now. And in case you haven't been in this room before, there is a little dot on the table that looks like a sticker. That is the button to turn on the microphone, and when it is red, it is hot. So that means it's time to talk, not time to stop. And please go ahead whenever you're ready.
Good afternoon, Madam Chair, members of the committee. Russell Rowe here on behalf of Tesla. We are here in support of this legislation to reduce barriers to HOAs, which is critical really to increasing access to clean technologies for folks, particularly in older HOAs where perhaps the design of the community really doesn't make for easy charging, home charging, and it also provides these HOAs with an opportunity to install a common charger for the community and do so without additional cost to the homeowners, because they could actually charge for that service. So it really makes sense. About 10 states thus far have adopted similar legislation, and we would encourage Nevada to do the same. Thank you.
Good afternoon, Chair, members of the committee. For the record, my name is Christy Cabrera Georgeson, CHRISTI, I'm the Deputy Director of the Nevada Conservation League, and we are here in support. We were also supportive of the original bill language. We felt that made an important step to ensure that homeowners or tenants were able to install charging at their home, so we were disappointed to see that go. We are still in support of the bill and making progress to allowing HOAs to have charging infrastructure in the common areas. But as I'm sure you all know, transportation is our state's largest source of pollution as well as greenhouse gas emissions, and vehicle electrification has significant potential to lower pollution, improve air quality, and enhance public health. The environmental, health, and economic benefits of electric vehicles are encouraging more and more Nevadans to make the switch, myself included. And so this bill will help ensure that EV drivers have a place to charge. Thank you so much.
Thank you, Chair and members of the committee. My name is Olivia Tanager. For the record, I am the director of the Sierra Club's Toyabe chapter. We're the largest grassroots environmental organization in the state of Nevada. Because 86% of EV home EV owners do some of their charging at home and rely on home chargers. It is critical that homeowners, whether they live in an HOA or else, have freedom to install chargers in the home that they own. Nevada, as you might know, is one of the top American states in EV adoption per capita. In 2023, 13% of vehicles sold in Nevada were EVs. We therefore should join other states in giving all homeowners the right to install EV chargers. EV prices are coming down and more companies are producing them. It is anticipated that close to 40% of car sales will be EVs by 2030. And with that, we are proud to support this bill and urge you to support it as well. Thank you.
All right, I don't see anybody else coming up to give in-person testimony in either Carson City or Las Vegas. So let's go to the phones for support testimony on SB 152.
Thank you, Chair. If you would like to testify in support of Senate Bill 152, please press star 9 now to take your place in the queue. Caller with the last 3 digits ending in 057, you are unmuted and you may begin.
Hello, this is Jerry Patterson. I want to thank Michael D. Lee for moving this amendment forward, because this was a issue that really needed the concern of everyone as the growing network of these EV chargers were needed, especially in growing areas vast as Clark County. And this is just something that we felt was just really holding us back in the future as the things were moving in the future. So all the support that's taking place, this is very appreciative that it is being brought forward for everyone to understand the good and the bad, but mostly the good for the growth for the state. So I want to thank everyone for that support from what we needed personally in the area. So thank you.
Good afternoon, Chair Scheibel and members of the committee. My name is Callie McKenna, and I'm here on behalf of Advanced Energy United. We're a national business association working to accelerate the transition to clean, modern energy and transportation. And our members include technology providers across the electric vehicle ecosystem. The transition to electric vehicles is happening, as you all know, and it is not slowing down. By the end of 2024, over 47,000 EVs were on Nevada's road, and that number is expected to continue to grow. Nevada has set ambitious zero-emission vehicle goals, and combined utility, state, and private incentives are already driving that shift forward. But for EV adoption to succeed, people need a place to charge, most often at home. SB 152 is a practical, forward-looking measure that protects consumer choice and ensures Nevadans can install and access EV charging when needed. It makes it easier for homeowners associations to install charging infrastructure in common areas, ensuring that outdated restrictions don't create unnecessary barriers to EV adoption. These updates provide clarity and consistency while balancing the needs of residents, HOAs, and local regulations. Expanding access to home charging is one of the most effective ways to support the EV transition, and the vast majority of EV charging happens at home, and homeowners and tenants alike need reliable and convenient access to charging stations. By ensuring Nevadans, regardless of where they live, can confidently charge, SB 152 helps reduce transportation costs, lower emissions, and supports the state's clean energy goals. As Nevada continues to lead in clean energy and transportation, SB 152 streamlines EV infrastructure and helps build the charging network that a 21st century transportation system requires. We respectfully urge the committee to support SB 152 and support a future where all Nevadans have equitable access to clean, reliable, and affordable transportation. So thank you, and I'm happy to take any questions.
Chair, the line is open and working. However, there are no further callers wishing to testify in support at this time.
Thank you so much. That takes us to testimony in opposition to SB 152. Anybody wishing to testify in opposition in person is invited to the front tables in either Carson City or Las Vegas. Looks like we have a couple people coming up to the table in Las Vegas, so I will invite you to turn on your microphone and please give us the name and spelling of your name when you begin, and then you may give your remarks. Please limit them to about 2 minutes each. Go ahead whenever you're ready.
Or 12,000 single-family homes in Southwest Las Vegas. I am opposed to SB 152 as it was introduced.
I'm
However,
sorry, we
the
didn't
modifications.
we didn't catch
Say
your
again?
name at the beginning of your testimony. I think you said it, but the mic cut out. If you could start over.
Okay, my name is Mark Leon. I'm a homeowner board member and board president of Mountains Edge Pasture Association, a community of 12,000 single-family homes in Southwest Las Vegas. I'm opposed to SB 152 as it was introduced, and as it's been modified, it goes a long way to alleviating a lot of the problems I had. As I understand from the people that introduced it, that the intent is that the charging station does not increase any cost to any unit owner or ongoing costs. The problem I have, though, is with line 17, where it says placement of the electrical vehicle charging station, but it only addresses the placement. It doesn't address things like the ongoing cost. I would suggest maybe that's a placement and operation of the electrical vehicle charging station. And also, it talks about not increasing any cost to any unit owner. It would also be great if it would say doesn't increase any cost and any liability to a unit owner. Thank you.
Whoever's next can go ahead.
Yeah, my name is Ben Wiebers, BENN-WIEBERS. And I own a condo and live at Boca Raton Condominium Community Association in Las Vegas. My remarks were based on the original proposed bill that was, we had a copy of when we arrived. I think the remarks, the way they're written, still pertains, even with the amendments, to give an idea of what our concerns were with this bill. I live in a condo HOA, not in a single family home that has a garage and is it part of an HOA. I believe the bill oversteps the authority that the legislature should have over homeowners associations and their members. As you know, HOAs are communities governed by a contract known as CC&Rs. Another very important aspect to how HOAs are to operate is the democratic principle of the right to vote. This includes the right to vote for or against projects such as electric charging stations. The bill ignores the rights of HOA members because it would authorize an HOA board to contract for the installation and maintenance of charging stations in common areas without the vote of HOA members. This bill would declare projects involved in electric charging stations to not be capital improvements when in fact they are. This is in opposition to HOA governing documents which require a vote on capital improvement projects. Also, the importance is the significance of cost of these projects, which includes purchase, installation, maintenance, and electrical costs. And I understand that the new amendment to this does away with that or attempts to, but I'm going to comment on if that amendment does not become part of this bill. Our HOA and its members cannot afford such expenses. In our particular case, the proof of that this is the case for our HOA is that we had over $11.5 million stolen from the association years back. And HOA members have had to pay special assessments ranging from $3,900 to $7,600 last year. And recently, our board has resorted to charging HOA members for the use of the event room and media room in our clubhouse, which have always been free of charge of our condo complex, which opened in 2007. It is not unreasonable to assume that other Nevada HOAs and their members also cannot afford significant capital improvements and related costs. But the bill takes away the right of HOA members to vote on such projects. As everyone is aware, commercial charging stations are being installed at a rapid pace in our state. In the near future, there is likely to be charging stations in near or reasonable proximity to most HOAs for owners of electric vehicles to conveniently use. I believe this bill is an unnecessary intrusion into the operation of homeowners associations. It must be asked, if this bill is passed, would this set a precedent for the legislature to continue to override the democratic process, which is fundamental in HOAs? Thank you.
Whoever's next may go ahead.
My name is Heather Scherlowski, spelled Scherloski. I did try to contact the sponsor, Senator Orenshaw, this week, but there was no answer and there wasn't an answering machine to leave a message. So I haven't had an opportunity to speak to anybody about this bill. I own a condo and I live at the Boca Raton Condominium Community Association in Las Vegas as well. I believe this bill oversteps the authority that the legislature should have over homeowners associations and their members. As you know, HOAs are communities governed by a contract known as CC&Rs. Another very important aspect to how HOAs are to operate is the democratic principle of the right to vote. This includes the right to vote for or against projects such as electric charging stations. This bill ignores the right of HOA members because it would authorize an HOA board to contract for the installation and maintenance of charging stations in common areas without the vote of HOA members. This bill would declare projects involving electric charging stations to not be capital improvements when in fact they are. This is in opposition to HOA governing documents which require a vote on capital improvement projects. Also of importance is the significant cost of these projects, which include purchase of the units, installation, maintenance, and electricity costs. Our HOA and its members cannot afford such expenses. The proof of this is that our HOA had over $11.5 million stolen from it years back. HOA members had to pay special assessments ranging from $3,900 to $7,600 last year. And recently, our board has resorted to charging HOA members for the use of the event room and the use of the media room in our clubhouse, which have always been free of charge since our condo complex opened in 2007. It is not unreasonable to assume that other Nevada HOAs and their members also cannot afford such significant capital improvements and related costs, but this bill takes away the right of HOA members to vote on such projects. As everyone is aware, commercial charging stations are being installed at a rapid pace in our state. In the near future, there's likely to be charging stations in near or reasonable proximity to most HOAs for owners of electric vehicles to conveniently use. I believe this bill is an unnecessary intrusion into the operation of homeowners associations. It must be asked, if this bill is passed, would this set a precedent for the legislature to continue to override the democratic process, which is fundamental in HOAs? And if I may just add, listening to the presentations earlier and the questions, I believe it was it Senator Scheibel? Someone was asking about whether you would be able to use your personal charging device in your parking space. And at our HOA, people have parking spaces, and some of them have electrical outlets by their parking space. So we've experienced people plugging in their cars and basically stealing the HOA money by not paying to have their vehicles charged. So if people can just plug into the HOA electrical system, and some people are able to do that for free, I guess I would say that's not fair to the entire membership of the HOA. So thank you for allowing me to speak. Thank you.
Good afternoon, Senators. My name is Mike Kozar. Kosor. I've been a board member of multiple HOAs for multiple terms. I speak in opposition, but I would like to first say that I have had an opportunity to talk with the sponsors and do appreciate their willingness to make changes to this bill so that it does meet their objective. And that, as I understand it, to simply cut through some red tape if it is the objective of this body to allow that to occur. So I'm going to make the assumption that if this is approved, you understand that you're making an exception and this is worth an exception. If that's the case, I will point out to you that if the homeowners are not allowed to vote on this issue, then they should not incur any cost whatsoever. And I think others have spoke to that. As written right now, that is not how the language is written, but I do believe that the sponsors will be able to come up with the right language so that can be in place. And this would include liability or the indemnification to homeowners that some of this may cause. I'd also point out one other item, and I think a couple of the questions from the senators address this, and that has to do with a section of NRS 116, and that's 345 section 3. It requires that if a project is installed within 500 feet of any homeowner, that homeowner gets the opportunity to veto it or at least vote in a majority. So that section, so that we have intent here, while it's not addressed in the bill itself, that is not your intent to allow that portion of the law to be exempted. So that the board could in fact go forward if there's no cost and without a vote. But I think it would be incorrect to allow that to go forward if, in fact, they're going to install it, for instance, in my back, right next to my backyard wall, and I don't have a problem, and I'd have a problem with having a charging station in close proximity to me. I think that would then be an additional step. So hopefully, if not in this statute, at least the intent is that that would not be preempted. I hope we can find conclusion. I believe that's possible, and I'll be happy to work with the sponsors as they have so far to come up with the right language that can get passed. Thank you very much.
All right, thank you all for your testimony. If there's anybody else in Las Vegas wishing to give opposition testimony, now is the time to come up to the front table. But I don't see anybody moving in Las Vegas or Carson City to the tables. So we'll go to the phone, please, for opposition testimony on SB 152.
Thank you, Chair. If you would like to testify in opposition to Senate Bill 152, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, we have no callers at this time.
All right, that takes us to neutral testimony then. I'll invite anybody here to give testimony in the neutral position up to the front in both Carson City and Las Vegas. Looks like we have some folks joining us in Carson City, so we'll start with you. Please go ahead whenever you're ready.
Thank you, Madam Chair and members of the committee. For the record, Garrett Gordon with the law firm of Womble Bond Dickinson, formerly known as Louis Roca, today representing the Community Association Institute, also known as CAI, who advocates for common sense legislation for the over, as you heard earlier, 3,000 associations in the state of Nevada. I first want to thank the sponsor for working with me and introducing me to Mr. DeLee. I had the opportunity to meet with him and give him some of our concerns with the original bill. The original bill our concern was it was almost a blanket approval for all unit owners to install charging stations and parking in their parking spaces. As you heard earlier, one size does not fit all for 3,000 associations. You have condos, you have townhomes, you have single family, you have leased parking spaces, you have deeded parking spaces, you have covered parking spaces, you have uncovered parking spaces. So it was kind of a complex bill to work through as originally written. We certainly appreciate the amendment, specifically the new section 1 that's permissive. It says the association may in 1A, and in 1B, again, the association may. I do think a lot of associations will take advantage of this, given the popularity of Teslas and other electric vehicles. The only reason I'm here in neutral, Madam Chair, in the committee, and not in support, you've heard it a little earlier, and I won't belabor the point, but the intent to say that this will not increase the cost in a unit owner, we think it's inherently will be a cost. If it's installing it, the electricity, the conduit, insurance, so it'll be a cost. So the question is, it's probably a modest cost. So either you spread that over all the unit owners, and it's not much, or maybe this gives the ability for the association just to charge a fee for whoever's using the charging station that would go to the association to cover that cost. We think that's probably more equitable than folks who don't have electric vehicles shouldn't be charged. If you're using the charging station, then there's a little fee to cover that maintenance and liability. It seems like an easy tweak. I've been working with the sponsor and Mr. DeLee and think we can get there before a work session. So thank you very much. And I know Senator Hansen always appreciates a good HOA bill, so it's nice to see you the first one in session.
Good afternoon, Chair Scheibel and committee members. For the record, my name is Chloe Chisholm, CHLOE-CHISM. I'm the Government Relations Advisor for NV Energy. We're here today in neutral. We would like to thank Senator Orenshaw for working with us on the language to address our initial concern. So I just wanted to put that on the record. Thank you very much.
All right, thank you so much. I don't see anybody in Las Vegas at the front to testify at this time, so we'll go to the phones, please, for neutral testimony on SB 152.
If you would like to testify in neutral for Senate Bill 152, please press star 9 to take your place in the queue. Chair, your public line is open and working. However, there are no callers to testify in neutral.
All right, then. I think that brings us to the conclusion of testimony on this bill. Do the sponsors have any closing remarks? Please come on down and share those with us now.
Chair Scheibel, members of the committee, James Orenshaw, State Senate District 21. Chair, members, I hope you weren't shocked at how electrifying this hearing was, but won't give up my day job. And I appreciate, I've had a lot of input. One of the gentlemen down in Las Vegas, Mr. Kozar, we were able to have a conversation last night. I know he talked to Mr. DeLee, and some of his concerns were reflected in the amendment. As to the veto power of someone who lives near where charging stations might put up, that's not something that he'd mentioned to me last night, but I'm certainly happy to talk with him. I believe Senate Bill 152 has the ability to benefit the association, benefit the unit owners in the association, and also help members of the association unit owners who are on the fence and might consider an electric vehicle have more confidence that they'll be able to charge it within their association and have it be convenient and easy for them. And with your permission, Chair, if I might allow Mr. DeLee just to address some of the comments that were brought up.
Please go ahead.
For the record, Michael DeLee, to Senator Scheibel. Several of the comments looked for additional clarifications. We're certainly open to working with the comments that were presented. Some of them I think might have been more directed towards the original version of the bill, so we're happy to be past that. And we're hoping to move some of the neutrals into positive by further clarifying that the costs are not to be spread out, that they truly are not to be passed on any cost, whether it's in a reserve study or in any other format. So if someone's going to do this, it truly must be neutral, and we do consider the liabilities and indemnification should be part of any of that. So we will take that seriously and work for the proper language so that this can benefit everybody under an arrangement for an electric vehicle charger. Thank you.
Thank you so much. All right, that brings us to the conclusion of our hearing on SB 152. I will now close the hearing and we'll move on to the last item on our agenda, which is public comment. Anybody wishing to give public comment in Carson City or Las Vegas is invited to the front table to do so now. But I don't see anybody moving in that direction, so we'll go to the phones, please, for public comment, and please remember to limit your remarks to 2 minutes.
Thank you, Chair. If you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, there are no callers at this time.
All right, then that takes us to the conclusion of our meeting for today. We will be back again tomorrow, same time, same place. And until then, we are adjourned.